Good afternoon and welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We of course welcome those who join us on all of these occasions on our heritage.org website. Would ask everyone in-house if you'll be so kind to check that cell phones have been turned off as we prepare to begin. It is always appreciated. And of course we will post the program on the Heritage homepage for everyone's future reference, and our internet and online viewers are always welcome to send questions or comments at any time, simply emailing speaker@heritage.org. Hosting our discussion today is Darren Bakst, who is our Research Fellow in Agricultural Policy in the Thomas A. Rowe Institute for Economic Policy Studies. He studies and writes about agriculture subsidies, property rights, environmental policy, food labeling, and other related issues. Before joining us at Heritage, he was a policy counsel for the U.S. Chamber of Commerce, where he focused on regulatory reform as well as food and agriculture policy. Previously, he served as Director of Legal and Regulatory Studies for 7 years at the John Locke Foundation of North Carolina, where he concentrated there on property rights and environmental policy. He serves on the Federalist Society's Environmental Law and Property Rights Executive Committee, and previously was a member of the Energy, Environment, and Agriculture Task Force of the American Legislative Exchange Council. Please join me in welcoming my colleague, Darren Bakst. Darren?
Thanks, John. I want to thank everybody that came here and everybody's watching online right now, especially since there's a sporting event that I'm not going to mention because I don't want you leaving. I was thinking, we were talking about this earlier, about having like a little crawler on the screen like ESPN has, but apparently PowerPoint doesn't have that. We're going to be discussing a critical issue that could have far greater implications than most people in the public at least realize. The EPA and the Army Corps of Engineers, through their proposed Waters of the U.S. Rule, are defining terminology that will clarify the scope of their jurisdiction. And last time I checked, agencies don't intentionally, on their own, decide to limit their own power. And when it comes to the Clean Water Act, both the EPA and the Corps have a history of trying to grab more power. And these attempts have actually been shot down by courts. And I see that with a sound of surprise because courts don't usually shoot down these type of overreaching by agencies, but they have, at least in the Clean Water Act context. As is usual, and could be describing thousands of other situations, Congress delegates too much power to agencies. Courts then defer too much to agencies. So there's really no checks on the agencies. And then further, as with the Clean Water Act, the agencies develop rules that reflect what they want the law to be, not what Congress intended the law to be. And today's panel is designed to outline the key aspects of this proposed Waters of the U.S. Rule, but also to show the wide impact that it's going to have across industries and across the nation. And the way we're going to work this is each panelist will speak for about 10 minutes, and then we'll have plenty of time for Q&A. So I'm going to introduce the panelists briefly, and so we can get on to the program. Our first panelist, closest to me, is Virginia Albrecht, who is special counsel at Hunton & Williams. Her practice focuses exclusively on environmental law and administrative law, in particular the Clean Water Act, Wetlands Program, the Endangered Species Act, NEPA, and other federal regulatory programs that affect the use of land. She has been lead counsel in several landmark wetlands cases, testified in Congress numerous times on the Clean Water Act, and had extensive experience litigating the meaning of the waters in the United States. Next will be Tabby Wakar, that's right, good, yeah. Who's a program manager for environmental policy within the National Association of Home Builders Advocacy Group. She analyzes regulation and legislation on the Clean Water Act, lead paint, clean air, floodplain issues, as well as other issues that arise within clean air and waste management. Prior to joining the National Association of Home Builders, Tabby worked as an environmental consultant to help draft a report for the Commission for Environmental Cooperation on spent lead-acid battery exports and secondary lead recycling in North America. And third, we'll have this gentleman here, Don Parrish, who's Senior Director, Regulatory Relations, American Farm Bureau Federation, and as he told me, he's just the water guy there. And honestly, let's see, I'm not sure I can read his writing, but he's chairing a bunch of councils that are important. So, but his focus is on the Clean Water Act. He recently testified for Congress on the Clean Water Act and this proposed rule. Then finally, Julie Uffner is Associate Legislative Director at the National Association of Counties. Ms. Uffner is responsible for all policy development and lobbying for the association in the areas of environment, energy, and land use. She joined the National Association of Counties in June of 2002 from the office of former Representative Phil English, where she had 4 years of legislative experience working on a number of issues, including environmental policy, human resources, energy, banking, and international affairs. And this time, Virginia, let's get it started.
Okay, Darren asked me to, in 10 minutes, give you a quick primer of the 42 years of history of the Clean Water Act jurisdiction. So, and in fact, I thought when I was coming over here this morning, what I really need is a blackboard, but I don't have a blackboard, and so I'm just gonna go through this and give you some highlights. And the reason we're doing this is because the rest of the panel is going to talk to you about the practical consequences of what EPA and the Corps of Engineers are proposing right now, and what's going to happen on the ground, and what's going to be regulated. And I was going to say, and what's not going to be regulated, but I don't think that's a null set. But really an important first idea that kind of gets lost because we talk so much about policy is that really what they are proposing is completely contrary to what Congress had in mind when they passed the Clean Water Act in 1972. It's contrary to what happened in Congress. From 2006 to 2010, there was a bill in Congress during the time the Democrats were in control of Congress, and it was sponsored by Congressman Oberstar, who was the chairman of the Transportation and Infrastructure Committee, and it would have done pretty much what this rule will do, and that bill did not even make it out of committee. And so as recently as this 2006 to 2010 period, Congress was saying, no, we're not going to do this. So I want to just get in the Wayback Machine real quick and tell you, give you this legal framework. And so you start in 1972, Congress passed the Clean Water Act, and for the first time ever established this permitting program which said, if you discharge pollutants to the navigable waters, and that was the term, navigable waters, you will have to get a permit. And this was a sea change. It was, this was an amazing change in the way we were addressing water quality. And we can go into that another time. But anyway, so the statutory term was navigable waters. We're going to regulate discharges to navigable waters. Then Congress, trying to be helpful, defined the term navigable waters as, quote unquote, the waters of the United States. Oh, all right, who knew? So there was a lot of back and forth about what does this mean? Navigable waters, on the one hand, is the statutory term, and the defined term is waters of the United States, which notably does not have the word navigable in it, but also notably has the phrase of the United States, which for the lawyers in the room is a signal that we're talking about waters that are of the United States as opposed to waters that are of the states. And those are different categories of waters. So that's the basic thing. So back and forth, back and forth. 1985, the Supreme Court took cert on a case called Riverside Bayview, which involved a wetland that was abutting a navigable waterway that was called Black Creek. And the applicant was saying, you can't regulate, the statute says navigable waters, you can't regulate this wetland, it's not navigable. And the government said, you know what, we've just gone through this huge rulemaking, and we have determined that these adjacent wetlands like this are inseparably bound up with the navigable waters, and therefore, in order to protect the navigable waters, we need to protect these wetlands. And the Supreme Court 9-0 said, yes, you have that authority. And they said, Congress's use of the term waters of the United States to define the term navigable waters indicated that Congress intended to regulate at least some waters that are not navigable. And again, not a lot of clarity there, but they're basically, okay, so you can go beyond waters, and they talked about waters that were inseparably bound up. That was in 1985. So in 1986, the agencies are just feeling their oats, 9-0. They've won this great, huge victory. And they adopt a policy that has come to be known as the Migratory Bird Rule, but it wasn't really a rule. But it was a principle of jurisdiction. And under the Migratory Bird Rule, they said, when migratory birds cross state lines, their crossing the state lines has an effect on interstate commerce. And therefore, if a migratory bird would land in a particular water body, we can take jurisdiction over that water body. Well, you don't have to think about it very long to realize that you cannot really imagine any water body that a bird would not land on. And so this gave them the power to really have very, very, very broad jurisdiction, very remote areas. And it was not tied to the size of the water, how long the water was there, whether it was a puddle, whether it was actually a water body, or anything else. And so it gave the agencies a lot of discretion. And there was a lot of litigation that went on between 1986 and 2001. And in 2001, the Supreme Court took cert in the second big case, which was called Solid Waste Agency of Northern Cook County, SWANC. The Solid Waste Agency of Northern Cook County, how am I doing? Okay. We're about 2/3 of the way through. Solid Waste Agency of Northern Cook County were 22 municipalities right outside of Chicago who had banded together to have a municipal landfill. And they had picked for their site an abandoned quarry it was an old quarry. They had bought this abandoned quarry, and at the bottom of the quarry, and anybody who lives in states that have quarry will be familiar with this, there are these little depressional areas and at the bottom of the quarry. And in the little depressional areas, it would rain. It was Illinois. It would rain occasionally. Water would fill up these little ponds, or these little depressional areas. Ponds would form. Birds would come. Migratory bird rule. We have jurisdiction. This is at the bottom of a quarry. Court took jurisdiction, denied the permit to the landfill, and so the municipality sued. They went to the Supreme Court, and they won, 5-4. And they said, you can't take jurisdiction. This is too far removed. These are these depressional areas that are in the bottom of a quarry. What do they have to do with navigable waters? So the Supreme Court said, you're right. And the Supreme Court kind of looked back at Riverside Bayview and said, in Riverside Bayview, we said you could go beyond navigable waters, but we said we wanted to go to at least some waters beyond navigable waters. We did not say you could read navigable out of the statute. And the attempt to regulate these ponds that are at the bottom of this quarry, what has that got to do with navigable waters? When Congress passed the statute and used the term navigable waters, they were exercising their power over navigation. And this thing at the bottom of this quarry has nothing to do with navigation. There's no connection, et cetera. So you can't regulate it. They also said, and this is a very, very important point, especially for Julie's folks, they said, when an administrative agency goes this far, you have to find a very explicit congressional intent to regulate this far, because they were going so far that they were regulating and moving into areas that were traditionally the province of state and local government. And so we need to look for, is there actually an explicit congressional intent? And they looked around the statute and they said, no, there's no explicit congressional intent. And in fact, the only congressional intent on this we can find is to the contrary. In Section 101B, Congress said, we intend in the Clean Water Act to preserve the primary rights and responsibilities of the states to manage their own land and water resources. So I said, you can't do this, it's going too far, and you've got to tie things to navigable. Okay. So after Swank, the agency said, oh, okay, we can't use birds. And the reason we didn't have jurisdiction was because these ponds were considered to be isolated. So if we can find that a pond is not isolated, we'll have a basis for regulating it. So they began searching for connections, things that used to have been thought of as being isolated. They would say, well, is this really isolated? And they would look for ditches, or they would look for water running across the landscape. And they would say, if you've got a kind of remote area up here, and you've got a traditional navigable water down here, and if you can imagine that the water will get from here to there, then you have a connection, and that's enough. You've tied it back to navigable waters, as the court directed us to do. Now, this was also highly controversial, and it resulted in the third big case, which is called Rapanos, which was decided by the Supreme Court in 2006. And in that case, what we had were these wetlands that were adjacent to ditches or drains, or these far upstream areas that were, in the case of the Rapanos wetlands, they were about 20 miles from the nearest navigable water. There was a companion case, anyway, we won't get into that, but they were about 20 miles from navigable waters. But the government was saying, okay, we can regulate them because we can see that if you put a pollutant up here, it will eventually, get down here, and we're trying to protect down here. So we can regulate up here. The court said, no. We do not buy this any connection theory. You have not established that you have jurisdiction, and this doesn't work. The court then went forward and split in a way that we're now living with right now, where Justice Kennedy, writing only for himself, said, what you really need is a significant nexus. Mere connection is not enough. All you had here was this sort of assumption that because this is connected to that, it affects that. You're not establishing that. You need to show that something has significant relationship to the downstream navigable waters, that it really, really affects those. The four-member plurality said, no, we don't go with the significant nexus. We like the idea that relatively permanent waters are regulated. Today we're going to be talking about what the government is doing in this rulemaking. And what they're saying they're doing is that they are applying Kennedy's significant nexus test and determining and identifying all the waters in the country that will have a significant nexus to traditional navigable waters, and writing a rule so that by rule all these things that they are designating will be automatically in. Now, it bears looking at what Kennedy was talking about. And when Kennedy looked at what the Corps was doing in Rapanos, and he said, here's what's going on. They've got these little water bodies that are way, 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 way far removed, and they're calling these little water bodies tributaries. And then they're saying this wetland is adjacent to this tributary, but I'm essentially pretty doubtful about what they're doing with these tributaries. And he wrote that what they're doing leaves wide room for regulation of drains, ditches, and streams remote from any navigable, in fact, water, and carrying only minor water volumes toward it. wetlands adjacent to tributaries covered by this standard, this any-connection standard that they were applying, might appear a little more related to navigable and fact waters than were isolated ponds and swank. And then he talked repeatedly about the need to look at water bodies and to see how big they are, how much water they have in them, how close they are to traditional navigable waters. These are all factors that should be considered in making a significant nexus determination. So he wrote that. Then that was 2006. Then there was this attempt to overturn both Rapanos and Swank through the Oberstar bill, which failed. And now I'm going to turn over to the rest of the group, because now what we've got is an attempt through a rulemaking to do what they couldn't get through Congress and what I think Congress was not talking about. And although they're claiming that this is really an expression of Kennedy's significant nexus idea, when you delve down in it, you see what they're regulating. Kennedy was really concerned. He was saying, you can't regulate these things that are remote. You've got to find meaning for navigable. You've got to, you can't intrude on local government and state government authorities. All of these things have sort of gone by the wayside, and I think you guys are going to talk about the practical realities. But the takeaway here that we wanted you to get is that there are some real legal deficiencies in what they're doing here, and there's a lot more that's legally problematic, which we could spend hours, but we won't.
Thanks. Now we'll hear from Tabby.
Hi everyone, my name is Tabby Wakar. I'm with the National Association of Home Builders. I'm going to present on the home builder industry's perspective and our take and our concerns resulting from the EPA's proposed rule redefining waters of the U.S. The National Association of Home Builders is a Washington, D.C. based trade association. We represent over 140,000 member firms who design and construct and supply single-family homes. Our members build and manage apartments, condos, multifamily housing, and also engage in light commercial and industrial in construction of light commercial and industrial structures. Our members, additionally, also, and which is a focus of this rule, is they also develop land, and to an extent, we also foresee an impact on our members that do major remodeling to existing homes. Our members are projected to construct about 80% of the new housing in 2014. And finally, over 95% of our membership fits under the definition of a small entity under the U.S. Small Business Administration. NAHB and its members have been advocates of the Clean Water Act since its inception. We recognize that the Clean Water Act has helped the nation make significant strides in improving the quality of our water resources. Our members regularly design their projects to avoid sensitive areas, showcase natural resources, and mitigate adverse impacts. As an organization, we have tirelessly advocated for the Clean Water Act and associated permitting scheme that is consistent, predictable, timely, and focused on protecting truly aquatic features. NAHB continues to support implementing measures that honor the congressional intent of the Clean Water Act to provide a cooperative federal and state program where the agency's efforts are complemented by the state's efforts. Now, why is this proposed rule so important to our members? As Virginia stated earlier, Congress limits the Clean Water Act jurisdiction to navigable waters, which is further defined as waters of the U.S. And this proposed rule, as the original 1986 regulations, what they did was define waters of the U.S. Now, waters of the U.S. is a phrase that's used throughout the Clean Water Act in several different programs, and a lot of those programs, as you'll see on my slide, for example, 402, 404, and 303, those programs impact our builders. What is the most frequently used provision by our members is Section 404, which is the fill and dredge permitting program, because most of our members' activities involve are substantially focused on earth-moving activities. However, we are impacted by 402. Our builders often automatically get a 402 permit, regardless of whether something is a waters of the U.S. or not. And then also we're concerned in the 303 context because that will impact the states. It will require states to regulate even more water bodies under the proposed rule. We view we have three main concerns under the proposed new definition of waters of the U.S. Number one, we view that the proposed rule expands the definition of waters of the U.S., thereby extending the federal jurisdiction beyond what the Clean Water Act originally intended. It increases the regulatory uncertainty. It shifts the burden of proof of disproving or proving a water of the U.S. to the regulated community. The expansion uncertainty, those concerns arise from three key changes that are found throughout the rule. First of concern is the definition of tributary. Basically, for the first time, the agencies have provided a definition of tributary, limiting it to three criteria that must be found in a feature to qualify it as a tributary. In addition, they have also specifically stated that a wetland, a lake, and a pond are automatically a tributary, regardless of whether they have those criteria. And also, to couple that concern of the definition of tributary, they have provided two very narrow and limited definitions of ditches. Now, those are exemptions. Currently, the agencies are basically saying that we are codifying our existing practices. However, with the definition of tributary and these two limited ditches, the world of what will be regulated will expand, because only two types of ditches that have very qualifying criteria will be exempt. Second, we're concerned about the expand of adjacent waters. In the proposed rule, EPA and the Corps have expanded their jurisdiction beyond adjacent wetlands to all adjacent waters. And to further complicate that expansion, they have introduced new vocabulary into the regulation. For example, they have defined neighboring to include further vaguely defined terms such as riparian areas and floodplains. The concern there is that those definitions are based on very scientific considerations, and based on my discussions with consultants and engineers that often have to go on the ground and implement such criteria, they find that it's very complicated, and that the agencies should have used a more workable definition for those terms. And the issue there is that it will be the core individuals who will use their professional judgment to make those distinctions, and so that's an area of concern. And finally, within the definition of adjacent waters, in redefining neighboring, EPA has allowed itself to take jurisdiction over wetlands or waters that are adjacent through a non-jurisdictional connection, which is their shallow subsurface connection. Now, it's not defined what that connection is, so there is a blurred line where it ends and where groundwater truly begins, especially in states like Florida, where the water table tends to be higher than the rest of the nation. And so that's certainly our concern. And finally, we're concerned with the catch-all provision of the undefined other waters, which is subject to a case-by-case analysis, which is based on Justice Kennedy's significant nexus analysis. And our concern there is that the agency is taking liberty to aggregate similarly situated waters within a region or a watershed. And it's not clear exactly how those delineations will be made in lieu of those similarly situated waters. So the concern with increased expansion is that it will result in an increased transaction or compliance cost for our members, starting at the outset. When a member decides to develop a lot, they have to hire a consultant, or an engineer to do their delineations, to then apply for a permit, and then if if it is found to be jurisdictional, they have to compensate by mitigation, and resulting from that, there are post-construction maintenance issues, costs, and then finally, there are foreseeable liabilities, whether a JD is appropriate or accurate, and resulting in complications of if they are able to sell the property to the next buyer. In light of these increased costs, it often deters a builder from developing a lot, and that results in an increased cost of avoidance. And that is projected to affect the availability of developable land. And we already previously experienced an issue with an availability of developable land, so this will further exacerbate that concern. Finally, next, the increased uncertainty will result in increased delays. Already this process of getting a JD is troubled with backlogs of permit applications that are taking beyond the 60 days that the regulations require. And so this delay is unique to our members because they are mostly small businesses, and so they will, because they are limited, their time is limited, their resources are limited, and their financing is limited. This will increase the overall cost of their projects by increasing the interest costs paid on their bank loans that they have obtained to finance their projects. It will increase the time it takes for them to realize a financial return for their project. And this impact is not going to be limited to these small members. It will translate into adverse financial effect on the local communities where they are working, and it will, by delaying the completion of projects that are often considered to be beneficial to the community. So it will take that away. Finally, under the proposed rule, the agencies are changing the process for waters 1 through 6, that all the waters except for the other waters that they are saying that they will do a case-by-case analysis. However, for the remaining waters, they are going to take automatic jurisdiction. These are categorical determinations that the agencies are saying that they have automatic jurisdiction based on the science that they have established in the connectivity report. Now, this connectivity report basically establishes that there is a significant nexus in all of these waters. And so in this regulation, the agencies are saying, we have proven that these waters, when they meet the definitions that we have provided, are automatically jurisdictional. Now, this leaves the burden of disproving that body of science, 1,000 peer-reviewed articles, scientific literature, to the homeowner, the home builder or a private property owner, to disprove that this does not meet, for example, the definition of a tributary or the definition of an adjacent water that is neighboring. And so this will increase their costs, out-of-pocket costs, to challenge such a determination, or simply just sit there and take the determination, go through the permit process, and incur those costs. Finally, as you know, the residential construction industry is already one of the most heavily regulated in the country, while the other indirect, long-term effect that is not being realized is the impact on the home buyer. Oftentimes, when regulations increase and as a result the cost of a home builder in building such a home increases, that cost is passed on to the buyer, which is the homeowner. And thereby it will increase the overall cost of homeownership, which will ultimately eliminate buyers from the market. These impacts will negatively affect housing affordability and stifle economic development in a recovering economy. Finally, I have a map that it might not be very clear because it's so small, but basically shows what it will become automatically jurisdictional and what will remain subject to a case-by-case determination. And the only thing that remains is those isolated wetlands. Everything else would automatically be jurisdictional. Thank you. And I'll answer questions later in the panel.
Thanks. And now we'll have Don Parrish.
Thank you. Real quickly, Under the heading of a picture is worth 1,000 words, I'm going to show you some pictures. What's important, though, is two things. The Farm Bureau is making a lot of noise about this issue right now because we see this at the very fundamental level, impacting land use. And if the Farm Bureau is concerned, then everybody else should be concerned, and I think Tabby expressed it very well. There is no right in the Clean Water Act for a permit. Therefore, if EPA controls something, they can choose not to issue a permit, they can choose to revoke a permit, they can choose to veto a land use even before it's proposed, flat out. Now, why is that important? And let's see. This is what's changed, and just to summarize, and Tabby went over this, the definition of tributary, the definition of adjacent waters, and the definition of other waters. This is where EPA expands the jurisdiction. If you look at the current Code of Federal Regulations and you look at the extent to which they can regulate right now under the CFR, and I'm not talking about guidance documents, I'm not talking about agency policy, this right here is their jurisdictional footprint. What I want to call your attention to is this is a relatively small area, 48 square miles. There's 47 miles of permanent streams, 96 miles of intermittent streams. Permanent means they flow 24/7, 365. Intermittent means they flow no less than 3 continuous months, 24/7. Okay? Now, what I want you to notice about this map, two things. There's still white left on this map. You can do things on this map that you don't have to go to EPA and ask Mother May I. You also notice the gray lines. The gray lines are the roads. You can notice that those gray lines avoid blue lines, even the dotted blue lines. So ultimately, people try to avoid things that are fishable and swimmable, things that are waters of the U.S. Now, what happens under this proposal is the map turns blue because EPA is proposing to regulate as tributaries anything that flows, regardless of the flow, the volume, or the frequency. So all of a sudden, this is a land use scheme. It is a land grab. I don't care how you slice it. Now, what do those little blue lines look like? Now, this may look like a stream running through a cornfield, but this is just a runoff from a heavy rainfall event. And when that runoff leaves, there's going to be a bed bank and ordinary high water mark there. So that farmer's field is going to be a water of the U.S. whether the water is there or not. Here's another example. And another, and another, and another. This is going to put Clean Water Act, EPA right in the Corps of Engineers, right in the middle of what we do. That's 404. As Tabby mentioned, it's also going to impact Section 303 in terms of water quality standards. In terms of TMDLs, it's also going to impact Section 402 NPDES permitting. Anybody recognize this? This is a Google slide. Now, Tabby went very specifically through the definition of adjacent in other waters. That's the Fox River. Fox River just outside of Chicago. There's a blank area right in the middle of this slide where a pond used to be.
Oh, swank.
Under this definition of either adjacent waters or other waters, those ponds in Swank would be jurisdictional. That is an end run around not only Congress, but the Supreme Court. Now, why does that matter? Enforcement. The potential enforcement is going to go through the roof. There's going to be additional costs regarding permits. Tabby referred to that with regard to her builders. It's going to trigger all sorts of other consultations with Endangered Species Act, NEPA, and the Historic Preservation Act. Ultimately, it's going to be mitigation, and there's going to be litigation out our ears. So in the end, when EPA says we're not changing anything, you better get a grip, because they are. They've changed definitions, they've changed terms, and they're expanding. And it's going to have one heck of an impact on land use. Thank you.
Thank you, Don. Julie?
Good afternoon.
I'm Julie Uffner from the National Association of Counties. Thank you for inviting us today. NACO represents 3,069 counties in the United States. We have a concern over this proposed rule because of the definitional change to tributary. Counties own and operate many public infrastructure ditches that will be impacted. But before I really start about this, I want to talk about who counties are. How many of you live in a county? Okay, at least we're a little bit further ahead. 3,069 counties. They differ in size significantly. We have Arlington County at 26 square miles. You have a borough in Alaska at close to 88,000 square miles. Likewise, populations differ widely. 140 people to 10 million people. Significantly different. Counties all across the nation are different. If you've seen one county, you've seen one county. The challenge is counties are an arm of the state. So whatever duties they have are designed by the state. Even within the same state, counties could have different responsibilities. Traditionally, for example, counties have done elections, courts, jails. They're moving into other arenas: consumer protection, welfare, water quality protection, land use. But what's really important to know about our counties, NACO's counties, is that 70% of them, approximately 2,200, are considered rural, with populations less than 50,000. 50% of those counties have populations less than 25,000. The point is, they have very limited funds. They're limited by their state constitution, what and how they can tax their people. So if there's more state and federal mandates, it is problematic for counties to function. Also, for the roads, counties maintain 45% of the roads in 43 states. Many of these roads are in rural counties. Remember what we said about the population-wise? So any additional burdens really need to be carefully considered. In Clean Water Act implementation, counties and other local government groups for that matter, they're more than just stakeholders. They're partners in this with the state and federal governments because they are co-regulators with the Clean Water Act. So it's a different perspective than we're coming from the other groups. The Clean Water Act is instrumental in protecting our waters. Our counties are very supportive. They're on the forefront of environmental issues. They're out there with zoning and land use to protect waters and protect other waterways. They are strong supporters of the Clean Water Act. But counties are also responsible for public safety. The ditches that move water away from the road to prevent accidents, or the ditches used to move water away from homes or businesses that prevent flooding. It's something that we take for granted when the systems are working. This was briefly touched on before. Our big concern is the change in definition for tributary. Tributary can be a ditch. It's jurisdictional if it meets bed bank high water mark and connects directly or indirectly to a water of the U.S. Many of our public infrastructure ditches do this. They're generally built on an uplands. They run through a transitional area and they go directly to a wetland. So you're talking about the roadside ditches. Both sides of the road, next to a road, most roads are required to have them. You're talking about flood control channels, stormwater, drainage ditches, everything that is used to protect the communities. Counties currently now, let me back up. The current situation on the ground is counties are sometimes required to get Section 404 permits for maintenance. This is a big deal for counties. Sometimes there is an exemption that is on the books for maintenance. It is very narrowly crafted. Counties sometimes cannot take advantage of it. And it is inconsistently applied across this nation. What happens when a county is jurisdictional for Section 404 it generally means permitting time costs, permitting time goes up, the costs go up, and the process is very cumbersome. It was alluded to before. It also triggers a number of federal laws, Endangered Species Act, NEPA, and other impacts. And part of the permit process, counties are sometimes required to put special conditions in their permits. For example, one of our California counties says that they can only clean out the ditch 6 months out of the year because of endangered species concerns. So even though the process, the determination process can be challenging, it's sometimes of what happens afterwards. Again, these other requirements. Our California counties also, for the flood control channels, are reporting that for a 5-year permit, a 5-year Section 404 permit, that they have to start the process 3 to 5 years early. They have documented costs in the millions for one project. This isn't just limited to California. We have a Midwestern county who has documented over the past several years they've had 5 projects delayed by the Corps. It has conservatively cost them $500,000. Other counties have missed building seasons. These are real-world examples of what's going on now, and the concern of counties is if the definition is broadened, these problems are going to impact more counties nationally. Something that we really didn't talk about before, 2 other points that NACO members are concerned about: green infrastructure and stormwater. Stormwater is essentially a series of pipes, channels, ditches that collect and treat stormwater. Local governments have these through the MS4s, municipal separate storm sewer systems. MS4s are regulated under the Section 404 permit program, but currently they're not considered a water of the U.S. A number of counties have raised concerns that MS4s could be regulated as a water of the U.S. since they meet the ditch criteria. And MS4s are not specifically excluded in the Act. So instead of regulating an MS4 at, say, the point of discharge, the MS4 would then have to regulate pollutants that enter the system at the point that they enter the system. This means that an MS4 may then be subject to state water quality standards or TMDLs. This would be very cumbersome and expensive for a local government to comply with. They're already under Section 402 permits and the requirements. Green infrastructure, it's a tool used by local governments to take care of stormwater runoff. It's being promoted by the agencies as a replacement to traditional infrastructure, say concrete channels or conveyances. But under the proposed rule, green infrastructure isn't specifically exempt. This is relevant because you would need a Section 404 permit if your green infrastructure is in or near a water of the U.S. Stormwater detention pond, we see them all around. You see them for the big road projects or home builder projects. Those need cleaned out occasionally because their function decreases over time because of the sediment in them. If you need a Section 404 permit to clean those out, it's going to be more time consuming because on the ground, the Corps just doesn't have the staff that they need right now to do this information. And the proposed rule would apply to more than just this. Again, as Virginia said, it hits every section of the Clean Water Act. So if more ditches are considered jurisdictional, what is going to be the impact on, say, the pesticide general permit program? Counties out there are using pesticides for mosquito abatement, vegetation control. Are they going to be required to get more permits from the pesticide permits? How is this going to impact the states with the state water quality standards? These are really important questions to be asking. The bottom line is no one wants to ditch the Clean Water Act. The Clean Water Act is very important for everyone. It has protected all of us. We just want to ensure that we have workable definitions that everyone is clear about what is jurisdictional. Thank you.
But before we take questions, I did have one question for Don. I think I'll ask this. Can you tell us about this interpretive rule where basically the argument is that agriculture's got all these exemptions, so what are you worried about?
That interpretive rule is a disaster. I think it really exemplifies in the problems that it creates, exemplifies the complexity of the statute. And ultimately, what happened here is that EPA, the Corps, and USDA got together and they said, well, it's probably a good idea that we try to camouflage what we're doing. And we're gonna say that we're gonna give agriculture some exemptions that we thought already existed. And again, we thought Congress gave farmers the ability to use conservation practices, and they were understood to be exempt congressionally. This stipulates that they're not, and it also stipulates that you have to follow certain standards if you want to receive any benefit from it. We think it is an interpretive rule, or it is a rule, more or less a legislative rule, that should have gone through public notice and comment, and we've got some very serious legal concerns with it.
Thanks. Let's start taking questions. I have a question up here front. Just say your name and where your affiliation, if you
could.
could.
That question, one of the things I meant to ask is, what does it say about this proposal if the agencies have to explicitly exempt reflecting pools? Think about that. Think about how broad this proposal is if they have to explicitly exempt reflecting pools. I'm sorry, your question, please.
Jeffrey Barrett. Jeffrey Barrett. This thing doesn't seem to be working.
So,
Hello? You make that thing work, would you? Okay. Well, okay. If you can hear me, you can hear me. Jeffrey Barrett from the Madison Coalition. And one of the things that strikes me about this whole conversation is the fact that Congress is not involved. It's passed a law many years ago, and when all these problems go up, Congress doesn't seem to be addressing them. And there is an organization in town, and I just mentioned it's the Madison Coalition. I just want to, and what they're proposing is to solve problems like this of the administrative state, is for an amendment to be passed, which says that if 25% of the congressmen of either house or 25% of the states object to a particular regulation, then Congress actually has to vote on it, and the leadership can't stop it, and the committee can't stop it. Now, quite aside from the issue of whether such an amendment can be passed, there is a strategy to pass such an amendment. But if one did pass, hello there, if one did pass an amendment like this, I want to address this to the entire panel, would that be useful to you as a tool in which to do some of the things that which you're trying to do for your counties and your farmers and your home builders and all that sort of thing?
We're looking for every tool available. Again, we view this as a threat, and we're looking for every tool available at the Farm Bureau.
Same would be helpful.
I would just add that ultimately Congress is going to have to take action one way or another, I think, on this. I don't know if it's through some big procedural step that way, but if nothing else, I mean, Congress itself needs to define what waters of the U.S. is, not to keep expecting the EPA and the Corps to come up with the right definition. They're not going to. And when they come up with a definition, they need to take into mind that really the statutory definition is navigable waters. It starts there and needs to be based on that term.
What I might add is that 25% is a very low threshold, and what that does is it forces Congress to take action whether they want to or not.
Okay. Question?
Randy Randall. This seems like a huge unfunded mandate, okay? I got involved in this issue in Richmond, and we're saying, who in the hell came up with this idea? They always pass the buck to somebody else. So how do we address it from the county pushing back to the state? The state doesn't have enough money. The state said, well, EPA made us do it. So how do we address that? When do we have to put the comments on the record? Should a county step up? Or do we have to have an association or state step up? Who has the sway?
everyone should step up because this impacts everyone. From NACO's standpoint, we've been educating our members and working with our members to determine how it specifically impacts counties. If you go to NACO's www.naco.org, we have an information hub for counties that basically has a policy brief, a very comprehensive policy brief, and long and short comments that counties can use along with social media. We're really encouraging all levels of government to engage and submit comments. EPA has held a number of conference calls, however, those are not official comments. It is imperative that regardless, people submit on their specific impacts. Counties are going to have all sorts of impacts. Some counties, most counties do road functions, but there are counties that don't, that may want to weigh in from stormwater. I would urge anyone who is interested, educate your local and state officials on this. It is only recently becoming known at the states, and the states are trying to determine how this may impact them.
Thanks. Thank you. We have a question right here.
Hi, my name is Lawrence Kogan, and I have a question concerning the science that's currently being reviewed by the SAB that supposedly establishes with more certainty than not the connectivity of the waters. What have you all been doing to challenge the science, and have you been looking at a particular statute that's still on the books with a lot of detailed administrative guidance that the administration wishes wasn't there, so it's decidedly not invoking it?
Well, I know that as part of, NHB has submitted comments through the Water Advocacy Coalition, basically criticizing the science report, and also, you know, just as part of this rule, the major flaw is a procedural flaw. EPA has put forth a draft of a scientific report, which is supposed to serve as the basis for this rule, before it's final. So we had a draft out, and then we had a proposed rule out. And now, while the Science Advisory Panel Board is wrapping up with their review, we still have a proposed rule that is based on a draft scientific study. And the other criticism I would offer is that the connectivity report is basically a collection of peer-reviewed literature that is not specifically targeted for this proposed rule. It's basically literature that establishes some sort of connectivity to justify what the proposed rule is trying to do. If we're going to have a rule based on science, that science should be directed for the purpose of the rule. And so,
the reason I asked the question, there is a statute called the Information Quality Act.
yes.
Okay, and it requires strict peer review if this is, and what it seems to be, is a highly influential scientific assessment. That's the highest level of peer
Right.
review, conflict of interest, bias, objectivity of all science studies. Okay, the administration is circumventing it, because when you look at the proposed rule, it says it refers to the study, it refers to the rule, and then the science being in support of it as pre-dissemination for public peer review. There is no such thing as public peer review. Okay, we're not looking at crowdsourcing peer review. Okay, and the guidelines are very explicit about the distinction between APA notice and comment and the special administrative mechanism for reviewing science and technical information that federal agencies disseminate to the public as support for a major rulemaking. Now, we've seen this in Clean Air. In fact, we're challenging the endangerment finding from 2009. They used the same MO by calling every science assessment, when it comes out in draft form for public comment, a pre-dissemination peer review. Now, that's contravening, in the terms of this new utility air case in the Supreme Court, it's contravening explicit congressional intent. Now, they're going to say, the absurdity doctrine, we need to change the rule, i.e. the reflective pools have to be exempt, because we'd have an absurd result. The Supreme Court said that doesn't even fly as a good excuse for you to change the rule. You can't change Congress's intent unless you come up with an explicit justification for showing that Congress didn't mean what it said. But the IQA does provide a backstop, legally speaking, to challenge the science and to basically take it out from under APA, which it doesn't belong in.
You know, that's a really good point. And and I hadn't actually thought of that. So I always love to hear new ideas that I haven't thought of. So thank you. But the other thing I was going to say about the connectivity report that just is crazy is not only are they putting out the rule based on this connectivity report before the connectivity report has even been finished, which is obviously arbitrary and capricious and suspect and everything else. But the whole idea of trying to establish that water is connected to other water, we all know from 7th grade science that there are clouds, it rains, the water falls on the ground, it evaporates, it goes up into the clouds. All water is connected to all other water. Congress certainly knew that when they passed the Clean Water Act. And yet, they weren't saying we want to regulate waters in the United States. They said navigable waters, and they said waters of the United States. So they were talking about a subset of all these waters. And the whole idea that they're connected really does not help you understand what Congress was trying to get to. And so it's, in a way, I mean, we need to, and WAC and NACO and other people have really been looking carefully at the connectivity report. And really, when you listen to the people on the SAB, I mean, they're saying, wait a minute, connectivity doesn't do the job. There's a gradient of connectivity. And, you know, some things are really connected and some things are out there. And we got to find the sweet spot. But
let me give you an
an absurdity?
An absurdity.
Oh, sorry, I can't either.
And I gave this to the SAB panel. My backyard has a dog trail around it where my Brittany runs around the back of our house. And her trail intersects with the path that goes around the side of my house that connects to my driveways. My driveway connects to my street connects to a bigger street, and then ultimately to a county highway and state highway, and then ultimately to an interstate highway. EPA is saying by virtue of that connection to the interstate highway, I can regulate where my puppy dog runs around the back of my yard. That's an absurdity, and Congress did not intend for that to happen.
In response to what you're saying, there is an international connection here, even though you might consider it remote. It has something to do with the UN Law of the Sea Convention. And I know something about this because I helped Mr. Meese upstairs derail it 7 years ago in the Senate. UN Law of the Sea Treaty is 1/3 environmental regulatory. And it has protocols, which are mini treaties that are regionally based, both in the Caribbean and on the West Coast, that subject the United States. That the United States is a party to those treaties, but not to the master treaty. Therefore, these treaties govern regulation of waterways all the way up to the watershed.
Let me get a question in the back, right in the back corner.
Thank you. Myron Ebell, Competitive Enterprise Institute. I think that the technical issues and the science claims are to some extent irrelevant, and I would like to ask you, isn't it the case from Don's map that the goal of the EPA and the Corps of Engineers and the Obama administration is to regulate everything in terms of land use, so that you have to get a permit to do anything? If you add the Endangered Species Act, the Coastal Zone Management Act, NEPA, and wetlands regulation, there really isn't anywhere that they cannot assert jurisdiction. And it seems to me that, by the way, the Information Quality Act has been ruled by federal court not to be justiciable, so it's up to them to enforce it against themselves, and good luck with that. But is it not the case that we need to ask the question, under what authority does the federal government manage land and control land?
Well, that's why 101B in the Clean Water Act is really important. I mean, when the Congress passed the Clean Water Act, people say it's an example of cooperative federalism, and that, big parts of the Clean Water Act, the EPA sets the standards, the programs are delegated to the states, and they administer and do most of the work. But the idea is, under 101B and also 101G, that the traditional powers of the state over a local land use are preserved and should not be disturbed. And there's always been this tension between, as they go further and further upstream, they're getting into areas that are definitely local land use. Now, the Corps has regs that essentially say we need to respect decisions, land use decisions that are made by local government, as long as they don't do something bad to the water. And so it's a big problem. I mean,
let me just follow up. I would, as you're doing that, I would argue you're right. It clearly, you know, how else do you call a land grab other than to say you can't put a pipeline, a power line, you can't put a wind turbine, you can't put a solar project, you can't put a driveway on that map that I showed you without going to EPA for a permit.
Yeah, this is why I would question the support for the Clean Water Act that several of the panelists said. It seems to me we can support the aims of the Clean Water Act, but should really oppose the Clean Water Act. This largely should be a matter for states to decide. If some states want to regulate everything, like my native state of Oregon does, through its land use controls, okay. But if a state does not want to, it seems to me they ought to have the right to preserve a little bit of freedom for rural landowners.
Well, it's bigger than rural. It's everybody. Yeah. But I would agree. I would say that first map draws a pretty clear distinction as to where the federal jurisdiction stops. Everything else is regulated by the state. It's not unregulated. And I'm of the opinion, just like cooperative federalism in the Clean Water Act, when Congress passed the Clean Water Act, the underlying one of the underlying foundations was what? Fishable and swimmable. Those aren't fishable and swimmable. It's absurd.
And just, I want to jump in here because the good point about the federalism, the impact of state and local governments is going to be huge. And this is something we've looked at from the MS4 program. What if a MS4 is considered a water of the U.S., what is going to be the impact on local governments and the communities? So conservatively, you're looking at litter and trash laws, pet laws, could be laws on how you drive your car since brake pad dust contributes to pollution. So these are really things at the local level. Now, whether or not we should be regulating them, that's a completely different discussion. But the point is, it's going to tax local governments who are already taxed. And eventually, it's the residents and the businesses that need to pay.
Okay, we've got, sorry, go ahead.
Oh, no.
We've got one last question. I got to move it along.
Hi, my name is Corey Hubbard. I work with Center Right Nonprofits here in town. I want to thank you for your comments today. I appreciate mostly the kind of concern over the negative economic implications that we could see from this continued regulatory overreach. My father is a small business owner on the Gulf Coast of Florida. He runs a recreational fishing business. And as his very politically interested daughter, I've sort of taken keen interest in how these regulations could personally affect, my family business. So coming up to the Hill and trying to work on these issues that continued fish coastal communities are being, sort of heavily regulated. I wondered if you could, for the audience, sort of speculate on the actual motivations, other than just being a power grab, and maybe Darren, you can weigh in on this as well. What's the underlying motivation for this? And I kind of see it, maybe I'm biased, but sort of an attempt to protect, the innocent fish and birds in these coastal communities at the expense of what I see are the innocent, productive humans that depend on these same species to support their communities and their families.
One of the things that, I'll take that question, or at least start the answer to that question. I think Congress was comprehensive in how they designed the Clean Water Act. And if you look at the different pieces, they intended to keep EPA out of the land use business, but they also passed pieces of the statute under Section 208 and 319 to address agriculture, Section 402 to address stormwater in the urbanizing areas. So the problem that you have with this proposal is that EPA really likes the hammer that Waters of the U.S. gives them. It gives them the opportunity to make a lot more of the things that we do on the landscape look like point sources, and therefore they've got not only the hammer of their NPDES program, but they've got, you know, all these other statutes that combine with it. The Clean Water Act is comprehensive. The other statutes, it may not be as blunt, it may not be as a big a club as that NPDES, but it's what Congress designed the act to do. And again, it gets back to what Mr. Ebel said. If states and locals want to make sure that those trout streams are protected and it's you know, they balance that. They balance it with the economic, the social, and the environmental outcomes. I think this is pushing the environmental outcomes in a disproportionate way, in a disproportionately costly way, into the public arena.
Can I add
Sure.
one thing? Which is, I've just begun looking into this, so I haven't finished it. But, you know, one of the things that EPA has said repeatedly in defense of what they're doing is that the states are just unable to regulate the waters the way they need to be regulated. And so EPA needs to step in. And they put in the record a study that was put together by the Environmental Law Institute, which purports to examine the water quality laws of all 50 states, and sort of draws a conclusion that a lot of the states have restrictions on their ability to regulate beyond the Clean Water Act. And I began looking at this, and I haven't finished, so I don't know, but there are a lot of holes in this study. But it is this, it's really interesting because it gets to what is their motive. I think that they really believe that they need to have federal authority over these things because they think that only the federal government will actually take care of it the way the federal government thinks it needs to be taken care of, which is probably a correct assertion. The question is whether...
Even within their economic analysis, they assume that every wetland in this country will be paved over without this regulation.
Yeah. So I think when you look at this, like those of you who live in Oregon or you live in California or live in Florida, you live in New Jersey, you know darn well, I mean, your state is not going to let the place go crazy. And even the ones that they're sort of identifying as kind of the troublemakers. When you get into how the states address these things, every state has, it's a beautiful example of federalism, where a state will say, well, you know, it only rains 3 inches a year in our state, so we're really interested more in our groundwater than in the surface water because there isn't really that much darn surface water. And every state has different ways of doing that. And they're basically trying to override this in some and part of it is this criticism of what the states. Now, regardless of whether the states do it or not, that does not give them the legal power to do this. So that's not a legal justification for doing it, but I think it does sort of give you a window into possibly one of the things they're thinking. And it's very troubling.
Well, please join me in thanking the panel.